afternoon, lawyers. Welcome to the First Department. We have 21 appeals on the calendar. All but 4 are going to be argued. So I ask you to please, when I call your case, ask for the time that you need, not the time that you want. We have read your records. We're quite familiar with your cases, maybe more familiar than you would like us to be. So I will start with that. I remind you that the new policy is that you are allowed to argue without a mask. So you can take off your mask when you are arguing it. Please put it right back on when you are seated at your chair, okay? So let's get started with this. People versus Anonymous.
That's a submit.
Okay. So, okay, so that's submitted. De la Cruz versus City of New York.
Good afternoon, Carter Rice for the appellate, requesting 4 minutes and 2 minutes in reply.
Okay, so Appellant De La Cruz is 4 and 2. City of New York?
Yeah, Jeremy Pepper for the City of New York, I'm requesting
5
5 minutes.
minutes. Okay. L. Catherine is submitted. First Majestic Silver versus Heights. I do not hear you. Please speak up. Do we have anything for anyone for the appellant Heights? We don't have an appellant, so submit. Okay. So submit it. Maybe they went ahead and partitioned that property in the first place. So, Dakers versus BFP Towers.
3 minutes, 1 rebuttal, please.
So I'm sorry. Appellant ABM. Tell me the time request.
3 and 1.
3 and 1. Okay. Respondents.
4 minutes.
3 and 1 and 3. Okay. People versus Gonzalez. 3 and 2. People 3. Okay, again, please speak up. Beckman Coulter versus Jabel Circuit.
For appellants, we request
7 and 3, and you're going to need all of it. Beckman Coulter.
Good afternoon, Your Honor. I'm Chris Mendez on behalf of the respondent. I'd like to introduce my colleague, a woman's colleague, Charles McCloud, requesting to be permitted to argue on behalf of the respondent. We have 7 minutes, Your Honor.
7 minutes. Okay, your application is granted. Joseph V. Helpert.
5 minutes.
Tell me who you are. You, Miss Joseph? You're the appellant? Okay, do we have a respondent? Do you still wish to argue, Miss Joseph?
If the court will hear me, it may not be necessary.
It may not be necessary. I'd rather you submit. We're familiar with the case. We'll decide whether searching the record under the circumstances is appropriate.
Then I will submit.
Thank you. So that's submitted. Schwartz versus Mount Sinai Hospital. Okay. That's submitted. People versus Jones. They must all be at the Yankee game tonight. People versus Rodriguez.
For appellants, the representative holds number 4 and 1.
4-1 for appellant, the people.
Julia Cherry, first one, equal,
3,
three.
4-1 and 3. Thank you. People versus Dominique Dunne.
Yes, for appellate 5 and 2, please, Your Honor.
5 and 2 for Ms. Dunne. People.
For respondent, 5 minutes, Your Honor.
5. Thank you. Taveras versus Almodovar. Do we have appellant Taveras here? Thank you. So that's submitted. People versus Pedro Hernandez Chavez is submitted. Nestor versus Public Administrator of Nassau.
Yes, hi, good afternoon. James Harris for respondent.
Do I have appellant Nestor? Okay. So that's submitted. Wow. Ortiz versus Maxon.
Good afternoon, sir. Jeffrey present for the appellate. May I have 5 and 2, please?
5 and 2 for appellant Maxon. Ortiz responded? 5 and 2 on 5. Ramirez versus Mo Capital.
Good afternoon, Your Honor. Mark Pincus for the appellant, Moab Capital. I'll ask for 5 and 2.
5 and 2. Respondent Ramirez.
Good afternoon, Your Honor. For Mr. Ramirez, the agreement for 6 minutes, Your Honor.
Tell me again.
6 minutes.
6. Okay. So that's 5 and 2 on 6. People versus Sierra is submitted. Brennan versus Caltabiano is submitted. Clark versus Boyle.
Yes, Your Honor. Petitioner request more than one.
Okay, and Boyle?
Respondent BG request.
I didn't hear a thing you said.
4 minutes for respondent BG, please.
Okay, so 5. Okay, thank you. Okay, first case on the calendar, De La Cruz versus City of New York. So that's hold on for a second. De La Cruz is 4-2. You may begin.
Good afternoon. May it please the court, Carter Reich on behalf of the appellant Jose De La Cruz. This is a personal injury action where Mr. De La Cruz on March 14th, 2014 was riding his bicycle up the bicycle lane of 6th Avenue at its intersection with 36th Street in Manhattan, where he came into contact with an obstacle that threw him from his bicycle and he sustained.
We're familiar with the facts, but it would be helpful if you would address whether or not the city had prior notice of the defect that you claim caused the accident.
Yes, and what we argued was that the prior acknowledgement exception to the written notice law applies, which is recognized by Bruni, which says that prior written notice is not required where there are internal documentations that essentially serve the same function.
The documentation being the corrective action request?
Yes, and they were issued 65 and 57 days before.
Does the
Can you show-
correct,
Go ahead.
does that CARS report make any reference to the construction gravel or the debris that's mentioned in the notice of claim, or does it reference something else?
Well, I think it's a matter of interpretation, and that's a disputed issue of fact. When Mr. De La Cruz testified through a Spanish interpreter, he didn't say there was any sort of hole or depression. He said they were, circular black pieces an inch in
But
diameter.
counsel, we're talking about the cars. So is there any mention of a defect? A defect
No,
of
but a
condition?
car,
Please, allow me.
I'm sorry.
Is there any mention of a defect or a defective condition in any of the cars?
There is, yes, there is. There's a mention of an asphalt trench inside
But is that a
of con-
defect, counsel, as opposed to an incorrect repair?
I submit that it is a defect.
Asphalt versus concrete is a defect?
Yes, because the DOT regulations require that the roadway be
And
restored.
what relationship, if any, does that have to the presence of construction, gravel, or any other, or any other hazardous condition on the roadway?
Because if you look at the defect that he marked on the photo, he marked the precise location where the asphalt and the concrete meets, where you see in the vicinity of that
Why isn't that a
black
stretch?
circular
Why
pieces.
isn't that a stretch, counsel? How is, Vargas says that notice of one defect is not notice of another. So how do you get from A, asphalt to gravel?
Well, because it is the precise location of the accident, there's no question about that. The precise location that they issued these corrective action requests
So
for
you're arguing that
is
location
the
equals
location.
defect?
And there's loads of appellate division case law that say the nature, location, and specificity of the defect are questions of fact. The prior written notice law is in derogation of the common law, so it has to be strictly construed against the city. It makes no reference to what level of specificity is required for the notice. So appellant submits that that is a question of fact. It's been acknowledged by respondent that corrective action requests do satisfy that prior, that acknowledgement exception, and the DOT witness said that a corrective action request is a notice to create is a notice to a permittee to correct a defect in the roadway. And, you know,
Right, but the witness for also testified that there was no hazardous condition. He was talking about asphalt that needed to be replaced with concrete in the trench, right?
yes, but it's our position that his affidavit submitted 8 years after the fact, where he said, I wouldn't have left it in a dangerous condition, or I would have noted that, is completely not credible and requires reversal, because at the time of his deposition, he couldn't remember a single thing. He couldn't even identify a roadway in a photograph, which for a DOT roadway inspector tells you everything you need to know right there. His affidavit has absolutely no credibility, and he couldn't explain why, when he went there, you know, these trenches have signs in them that say who owns the trench, and he saw a sign in the trench that said Empire City Subway, but on 2 occasions he said, no, that's not the right person. I'm going to issue a corrective action request to Time Warner Cable. He couldn't explain what observations led him to believe that the sign in the roadway was wrong. And the inspector that went out there after the accident just immediately issued the corrective action request to the proper
Thank you,
entity, and the
counsel.
roadway got repaired.
Thank you, counsel.
Thank you.
Good afternoon. May it please the court, Jeremy Pepper for the City of New York. I just want to start by noting that this court should dismiss Dela Cruz's complaint because he failed to even plead that the city had prior written notice. This court has held many times that a failure to plead requires dismissal of complaint, failure to plead prior written notice.
But moving beyond yet that issue, the issue of the CARS report, and your adversary has indicated that the defects are the same in specificity, location. How do you address that?
Right. So I think that Dela Cruz, in his deposition, was very clear what caused his incident. He testified that it was loose construction gravel that was on the roadway, and it was 1 inch in diameter. I would like to note that diameter indicates that it was circular in shape. That's what that word means. The corrective action requests note that the roadway was patched using the wrong material. There's no indication that there was anything loose in the roadway, that there was debris, that there was rocks or gravel. And there's nothing that even indicates that the...
If it was patched with the wrong material, does that by itself constitute a defective condition?
I would submit that it was in violation of the DOT's regulations, but that doesn't necessarily indicate that it was a hazardous defect, right? An example we have in this case of the first corrective action request is that the paint was the wrong color, indicating the paint indicates who's doing the work. and that they used the wrong color. I don't think anyone would argue that that's a hazardous defect, that if we had just...
But this was more than just color, right? This was to do what? To restore with concrete rather than asphalt.
Right. A different material was used than the roadway, and than the roadway was made of. And I would submit that that alone, it's conclusatory to say that
So that alone is not a hazardous condition.
There's nothing in the corrective action request to indicate that it is. The requests themselves indicate that there was no differential between the roadway and the patchwork. It was 0 inches.
There has to be some reason why the city requires that you use different type of material for the pavement.
Right.
Correct? You don't just arbitrarily use 2 different things.
Right. We would want this. We would want the work to be done. You know, these companies come in and they cut open the roadway, and when they patch it, we want them to use the same material that the rest of the roadway is, because we want it to all be the same.
So, counsel, the cars indicated the location, the remedy, which was to restore the asphalt trench to concrete, and the depth of the trench, right?
Correct.
Which was a 0 depth.
Correct.
Is there any indication anywhere or any testimony anywhere that gravel constitutes part of the remedy? In other words, that the asphalt created a gravel condition of any sort, of if it was appearing in any way, surfacing in any way?
No, the DOT inspector, neither the DOT inspector nor any of the DOT records indicate that there was any gravel caused by this patchwork, or that anything even was wrong with the patchwork other than the fact that it was using the wrong material.
Your adversary argues that the mere fact of the location being in the same place, gravel as opposed to asphalt, means that there was notice.
Yeah, so I would address that. I would say that there's plenty of cases that say that awareness of one defect in the same area doesn't constitute awareness of a different defect. I would also direct the court to look at the cases cited to by the appellant. They all deal with plaintiffs being imprecise in their description of where the defect was, and not imprecise in their definition of what the defect is. I would draw an analogy to the Big Apple maps. If there's a marking for a raised sidewalk and someone says they tripped in a hole, I would argue that that's not the same defect, and so it couldn't be noticed. It's the same situation here. We had notice for an improper patchwork using the wrong material, which can't constitute notice for gravel. And my red light's on, so if there are no further questions, I'll
Thank you,
rest on my
counsel.
brief.
Okay, you got 2 minutes in rebuttal.
Thank you. I would just reiterate that restoring the roadway with an improper material does constitute a defect. And if you look at the photographs, specifically at 101 and 103 at the appendix, where Mr. De La Cruz marked with an X, you see something that is consistent with his description of circular black pieces. You see the patchwork around the asphalt that's circular and black, about 1 inch in diameter. All right, he doesn't say there's any sort of trench or depression, so that is consistent with the CAR that says 0 depth, even though the roadway inspector gave no testimony interpreting that.
How is the
Counsel, is
condition
there-
sorry.
Go ahead.
How is the condition that you're describing consistent with the description in the CAR that the trench has to be restored in concrete? I don't understand how you get from that to construction debris on the...
Well, he referred to it as not just gravel, but construction gravel, meaning that it was used in construction and it's on top of a concrete patch.
But there's nothing in the CAR that indicates that there was loose gravel. So I'm having trouble understanding how it is that you think that the CAR constitutes notice of your client's claim that there was loose gravel.
Well, I think at minimum it's an issue of fact, because the CAR is also lacking a lot of information, like why did the inspector conclude that it was Time Warner's trench when it clearly is labeled Empire City Subway's trench? He had no idea what observations he made, and you know, this affidavit after the fact raises even more questions that requires reversal. The motion court engaged in issue determination, and the role on summary judgment is issue finding. And the motion court found that there was this written acknowledgement, but then they went on and found that the written acknowledgement wasn't sufficient enough, and that invaded the province of the jury. The decision of the motion court should be reversed. Thank you.
Thank you. Thank you both. Dakers versus BFP Towers.
Good morning, Your Honors. Case is a little different, a little unique. It's entirely visual. It's not much, there's not much intellectual, cerebral coordination going on.
Well, it's visual in the sense, I mean, that video doesn't tell us much, does it?
If you look at page 24 to 25, you'll see, there's really two issues. One issue, I think, is clear, that the accident never happened the way the plaintiff said. You see the security guard, he doesn't fall. You see that he doesn't hold on to the wall. You see that she doesn't fall on her back. All that is manifestly untrue. Getting to the other issue, though, could there have been some dust on the floor? Look at 24 and 25. It's so obvious that what you're looking at is light. I sent out, I think, 5
Sorry,
minutes.
did you say light?
Light, reflection of light on the floor. You could see the people walking past the shadows, and that light, which is right next to the mat, is when people walk past it, it goes away.
Well, why, oh, go ahead. No, I'm just wondering, your interpretation of the video, why isn't that a question of fact? I mean, that's how you interpret it. Someone else can interpret it another way, right?
We're talking just about the light, right?
I'm not talking about light at all. You are.
The other things, there's no, I don't see how there could be any dispute. She doesn't fall with her on her head. The security guard doesn't walk over and almost fall. They don't get up and have to hold on to the wall to leave.
So you're surmising that dust could be picked up on by a surveillance camera?
It's not only a surveillance camera.
Even though, counsel, please.
I'm sorry.
Okay, so I saw the video this afternoon. So I saw the video this afternoon. So the floors, they're marble floors, and they look like they're white or they're light. I know that it's hard to see dust. We all know this in our common experience. How could a camera see dust on the floor from a great height?
I would ask you to look at page 24 to 25. It's not a surveillance camera up in the air. It's a camera that's taken at ground level right there. You can see the lines of light coming in, the geometric forms. You can see people standing there, and when they move over, it goes away, and when the light comes back, it comes back.
Do you agree that the video points to the plaintiff sleeping on the metal crate in front of the escalator?
There's no doubt about that. It was raining that day. There's no doubt that she fell. Many people
Counsel,
fell.
Can we tell what, if any condition exists on the floor? Is there dust? Is there water? Is it dry? Can you tell? I couldn't.
I would say from 24 and 25, the photographs, I don't see how it could be much clearer.
Counsel, I'm looking directly at 24 and 25 as we speak. I have to disagree with you, having taken many photographs and looked at many photographs, for you to claim that you can tell with certainty exactly what the condition of the floor is from that. There's light in different directions, there are shadows, there's serrations in the floor. Photographs are good for many things, but that level of detail we can't see in those 2 photographs. Maybe if someone had taken a close-up, it would be different, but that's not a close-up, and I don't see how you can say that there's no question of fact arising from those 2 photographs.
The light's on, so I'll answer quickly.
I'll let you do it.
If you look at the moments that I pointed out, dust doesn't appear and reappear when you walk by it. You have a man with a cart. A man walks through the cart, through the supposedly dust. The dust doesn't move. There's no dust on the cart. There's no dust on the mat.
You're saying dust doesn't move?
No, the dust doesn't move at all. because it's not dust, it's light. And you see the cart go by, and you see the cart go right over the supposed dust, and what's happening is, for a second, there's a shadow, and then the shadow goes away, and the light is hitting it. And the light is in a geometric form, it's in a perfect circle.
Thank you, counsel.
May it please the court, my name is Alan Figman. I'm the appellate counsel and the trial counsel, and should this court permit this matter to go to trial against ABM, I intend to put that videotape into evidence on my direct case because it shows numerous factors that indicate that there was indeed something on the floor. It goes after the fact, and I recognize that subsequent elements are not proof of negligence at the time of the accident, at the moment of the accident, but it shows before the other fellow takes the picture, the security guard is going like this with his left foot, does that multiple times over the course of several minutes, 4 other people fall, and finally, 32 minutes later, somebody from American Express calls up ABM and says, please have a janitor put cones around this site. And you also see a security guard standing at the corner of the metal grate, and seemingly he's only there to warn people that, be careful, there's something here. And the plaintiff
We don't
testified.
know that that's why he's there, right?
Excuse me?
We don't know for a fact that that's why he's there, right?
No, but I think that, I think a jury will find that his positioning there is indicative of playing a role with respect to trying.
But it's not your burden to prove that it was there, right? On the motion for summary judgment, it's ABM's burden, isn't it?
Yes, I know, but I tend to get a little worked up when I think about it.
I got you. Save it for trial, though.
Okay. And I just believe that this is, well, it all boils down to the videotape. I've seen those tapes 100 times. I had to get a special computer to view them because the initial drivers were not updated for Windows 10, so I had to buy an old computer. And the cameras are very high up. It's not like she says she's walking through sand on the desert where you're going to see like footprints in it. It's just dust, and what happened is inside the grating, it became very wet and slushy. She testified numerous times under cross-examination type questions from three different defense counsels and was 100% consistent in her story every time. Said the accident didn't happen the way she said. It sure did. She never said she hit her head. She fell and landed on her back, on her butt, basically. And
Well, he's challenging, that goes to weight and credibility, right? I mean, whether it happened the way she said it did, it's good questioning for cross-examination for trial, not on a motion for summary judgment, deciding as a matter of law that she lacks credibility.
yes, Your Honor.
Okay, thank you, counsel.
Your Honor, the court already ruled in our favor. They said that there's no case if she fell on water or something else. The only case she has is if she fell on construction dust. They cited other ABM cases and said there's no proof that they did anything wrong because it was raining out, which she said it was. So the only issue is whether this was dust that made her fall. So I just wanted, and I'll just say one more time, it's manifestly untrue, everything that she said. She said she fell on her head. She said that the security guard fell. She said that they had to walk on the wall so they wouldn't fall down again. Look at that and tell me if any of you judges see that happening. It's manifestly untrue. Thank you.
Thank you. Thank you both. People versus Gonzalez.
May it please the court, Alma Gonzalez for Mr. Raul Gonzalez. The court should reverse and grant a hearing on Mr. Gonzalez's 440 motion with counsel. Aside from there being colorable claims of ineffective assistance of counsel, the claims couldn't have been decided without a hearing to explore counsel's strategic reasons, if there were any, for her performance.
Is your client, has he been deported?
Yes, he has been.
So he's no longer subject to the jurisdiction of this court, really?
Well, he is, Your Honor, because he's subjecting himself to the jurisdiction of this court by continuing on with the appeal. And if there would be a reversal.
Although he was sentenced in absentia right after he absconded.
Correct, yes. And then as soon as he did come back, he filed yet another notice of appeal and attempted to file a direct appeal, which was then dismissed by this court without counsel having been assigned.
This is a 20-year-old case, right?
From 2002, yes.
Given that he's already been deported, we have discretion, don't we, to dismiss this permissive appeal?
There would be discretion, yes, Your Honor, and we're arguing that you not dismiss the appeal. For one, it's been fully briefed at this point. And as well, you know, the consequences of this conviction are, for immigration purposes, are pretty severe. This is an aggravated felony, and so it means that even after the bar to his return would have passed, he would not be able to petition to come back to this country lawfully.
Well, you said you said the defendant came back to court. He didn't exactly come back to court. He was brought back to court on a
Right,
warrant.
yes, on extradition.
You made it sound like it was a voluntary.
Sorry, yeah. To be clear, no, he was back after an illegal reentry. Yes. If the court doesn't have any other questions with respect to the dismissal point, because we also did brief that in the reply. As we're saying, there should have been a hearing granted here. This is an ineffective assistance of counsel claim. Mr. Gonzalez did request twice from defense counsel to have an affidavit with her explanation for her performance. She responded to neither of those. So really the only way to resolve this claim would have been to bring in defense counsel to hear her testimony at a hearing in this case. This was also not procedurally barred. This is not a records-based claim. You can't really resolve an ineffectiveness claim without actually hearing the explanation from counsel, which obviously is not in the record. And in the second instance as well, Mr. Gonzalez was denied a right to counsel on this claim. Counsel could have been assigned to supplement the motion papers of these meritorious claims, and he could have also been represented at a hearing subsequently with counsel. So for those reasons, Your Honor, we do ask that you reverse unless there are further questions.
Thank you.
Good afternoon. Emily Aldridge for the people. Defendant's permissive appeal should be dismissed due to his involuntary deportation. And even if this court does not dismiss the appeal, the motion court properly denied the 440 motion without a hearing. Defendant raised only record-based claims. Due to his absconding pretrial, he could only raise record-based claims because that's all he had was the record. His claims are obviously a thinly veiled attempt to circumvent the dismissal of his direct appeal. He's raising veiled weight and sufficiency claims. And if there are no questions, I rest on my brief.
We good.
I would just make one quick note on the dismissal point. This court typically, with respect to, for example, SORA claims on appeal for registration, has said that it will not dismiss those claims even when the person has been deported because of the severity of the consequences. And we would argue that having an aggravated felony, which prevents you from ever returning to the United States, is as severe as those consequences, so there should not be a dismissal here. And again, this is not a veiled attempt at an insufficiency claim. We're well aware that we cannot raise that here since his direct appeal was dismissed. The point is that these were ineffective assistance of counsel claims, and we did need defense counsel's testimony at a hearing. Thank you, Your Honors.
Thank you. Thank you both. Beckman Coulter.
Good afternoon, Your Honors. May it please the Court, Rachel Sparks Bradley of Simpson Thatcher and Bartlett on behalf of appellants Jabil Inc. and Nipro Inc. The core question on this appeal is whether Jabil has stated fraud claims against Danaher and Beckman in addition to the contract claims that were not challenged on the pleadings below. And we submit that Jabil has stated such claims and thus that the motion court's decision dismissing those claims was incorrect. The fraud claims address different obligations than those in the contracts and seek different damages. Jabil has stated these claims with the requisite specificity required by the CPLR.
Counsel, just to push this forward, the issue of the company that was to replace Beckman, and why wouldn't Jabil have been on inquiry notice as to that happening?
Well, Your Honor, certainly the issue of Cepheid, the company which did not replace Beckman but replaced a portion of Beckman's business, or rather Danaher, as we understand the facts now, Danaher took a portion of Beckman's business, a line of products that used Jabil's PCBAs, and transferred it to this new subsidiary of Danaher called Cepheid. The transaction was announced publicly before the deal here was closed, and so certainly the Cepheid deal was discussed as part of the transaction, but at no time was it ever disclosed to Jabil that there were these apparently completely secret plans to cannibalize an entire product line and thus materially impact Beckman's ability to source PCBAs.
Did your client ever inquire as to whether the acquisition of Cepheid, is that how it's pronounced?
I believe it's Cepheid, but...
Cepheid, that the acquisition of Cepheid would have any impact on its revenue from this deal? I didn't see any record I didn't see anything in the record that would suggest that your client ever made inquiry once it learned about this to see whether it would have any impact on its revenue.
Standing here today, Your Honor, I'm not able to say whether that specific question was asked. However, to the extent
that a part of due diligence? If you learn about something like that, isn't it the obvious thing to ask the follow-up question? How does that affect me?
For all I very much expect that that was asked. I simply cannot make that representation.
I couldn't find it in the record, counsel.
There was more than a year of diligence. As I mentioned, that deal happened prior to our deal happening. The Cepheid deal was announced in the end of 2016. The deals here were effective as of May 2017, so it was before. And our position is that because Danaher and Beckman apparently knew about this plan to take a product line from Beckman, they were under a duty to disclose that to Jabil as part of these contract negotiations, given the material impact that it could have, and in fact did have, on the PCBAs that Beckman was able to order from Jabil pursuant to this contract. They simply...
But isn't that part of, it's sort of your own inquiry notice, right? You know that there's going to be an acquisition. It may be a secret plan to, you allege it's somehow a scheme of some kind, but could your client have simply asked, or through the ordinary intelligence or diligence, be able to find out by simply inquiring?
Well, Your Honor, our position is that having simply asked that question wouldn't reveal a secret scheme. That's the nature of a scheme, is that if you say, hey, are you going to defraud me? Hey, are you planning to materially impact this deal that we're negotiating? That we wouldn't have gotten a truthful answer, that all of that was concealed.
But if you had a record that shows that your client had asked the question and that Beckman had intentionally misled them as to what their plan was, you'd be in a very different situation. But I don't see anything in the record that your client asked any of the logical questions. How does that affect our business?
Well, Your Honor, then I submit that that would simply be a matter of needing to replead. I think, however, the inference is right there in the is right there because we have various representations in the, various statements in the pleadings about how Beckman and Danaher talked about their commitment to growing Beckman's business, expanding the business, the high demand for Beckman's products. All of that.
And your client couldn't ask, well, how is that going to impact Jabil's economic interest?
And as I said, Your Honor, I have every expectation that it was discussed. I think everything was discussed. The issue is, even if that specific question was asked, do we have any reason to believe that Beckman would have told the truth or Danaher would have told the truth?
But
And
if you don't ask, I mean, clearly they had a duty to disclose, you allege, right?
Yes, Your Honor.
At least based on sports tech, which is this department's decision 2020, clearly there is a duty.
Yes, Your Honor.
Is this something that you could have discovered by simply asking DNB?
And our position is no, because looking at what we think is the most reasonable inference here, the revenue levels when all of the PCBAs were being manufactured by Beckman and by Beckman's third-party manufacturers were at a certain level. And then somehow, just a few months later, when Jabil takes over the manufacturing, suddenly the numbers are very, very different. They're much lower. So there seem to have been affirmative misrepresentations about historical numbers, as well as indications from Beckman and Danaher that these numbers were actually predictive of the future.
What were the specific misrepresentations that you claim?
So, for example, Your Honor, in paragraph 51 of our counterclaims, that's at record 96 and 97, we discuss a profit and loss statement that showed revenue for years prior to the deal. And it doesn't make any sense that the revenue would be at those levels in the few years prior to the deal, and then suddenly in 2017 materially drop by 30–40%. Just because Jabil took over the manufacturing. Who manufactures the PCBAs has nothing to do with who is buying the ultimate products that Beckman creates.
Counsel, I'd like to follow up on that in terms of what due diligence you did with regard to the estimates of the PCBA volume and income in the future, because at one point I saw on the record that your client had asked them, had asked Beckman for certain invoices, and Beckman refused to turn them over. But your client went ahead with the deal anyway. Wasn't the fact that you asked a question and they refused to answer it give you some reason to be suspicious? And if you chose to go ahead with the deal anyway, why should we let you out?
Particularly in light, and I agree with that, particularly in light of the MSA and the project agreements, sort of disclaiming any extra contractual representations or promises, right? So you were on the hook.
So if I may respond.
No, of course.
Thank you, Your Honor. So to the...
That light is for you, not for us.
Okay, I just wanted to make sure, thank you. So if I may, I'll address the questions in reverse order, if I may. So with respect to the disclaimer, certainly there is a disclaimer of reliance on representations. We maintain that under this court's cases, including the recent IBM versus Global Foundries case, that this is not, it's not a specific enough disclaimer to cover what we allege to be the misrepresentations at issue here. And with respect to the invoices that you specifically asked about, it's true that there were certain invoices for third-party manufacturers that Beckman had used that it did not turn over to Jabil. However, it provided alternative forms of diligence in the form of spreadsheets listing out what were those invoice amounts. There was nothing that gave Jabil reason to think that Beckman, Coulter, and Danaher, otherwise very reputable counterparties, were deceiving it, and thus we submit these were not red flags of the sort that we see in some of the cases.
Thank you.
Thank you.
Thank you, Your Honors. Charles McLeod of Williams & Connolly on behalf of Beckman and Danaher. Let me start with the Cepheid allegations. Your Honors were exactly right. The reason that you weren't able to find any allegation in the counterclaims that Jabil did diligence on Cepheid is because it does not appear. There's no allegation that they ever asked the obvious question.
How would they know if it's a scheme to replace their product within the, how would they know that? what inquiry could they have made?
Well, Your Honor, they could have done two things. The first is they could have asked us what were our plans, and if they had received a false answer to that question, that could be the basis for a fraud claim. The other thing they could have done in that circumstance is to insist on representations and warranties that would protect them. That's what the cases like Rodas say that parties in these circumstances should do. They didn't do that either, and in fact, they agreed in paragraph 3 of the MSA that Beckman and Danaher have the right to source PCBAs from other third parties or to make their own PCBAs. And so there's no basis in this agreement for a claim based on the Cepheid transaction. There was simply no duty to disclose. Counsel suggested that if they had asked the question, they might have gotten a false answer. And I would submit that adopting that standard, a standard where a party can allege fraud if they think they may have been defrauded, if they did diligence, would be a dramatic expansion of fraud law in the state and one this court should not undertake.
Counsel, you seem to be relying heavily with regard to the Cepheid argument on the 2016 documents concerning your intention to buy that company. But that document doesn't say anything about the fact that it would be given, that your client was intending to turn over to it a product line which it had been represented would be given to Jabil to produce, right? I didn't see anything in that in the 2016 documents, which I think were at pages 185 and so on of the record, that would have given them any hint that that was your intention.
Well, Your Honor, I think it was clear from those documents that Cepheid was going to be part of the diagnostic space for Beckman and Danaher. And so I think given that information, it was incumbent upon Jabil to ask the question of how is this going to...
Do we know that they didn't ask? I mean, counsel seems to suggest that that's just a repleting issue.
Well, Your Honor, counsel is a very good lawyer from a very good firm. I think if they had asked the question, it would have been the original counterclaims. It's not there, and I think it's because the question was never asked. And at a minimum, you know, setting aside...
Well, did you have a duty to disclose? I mean, I assume that you agree that this was material, right? It was definitely going to impact them, right?
Well, it could be material. I think part of the issue here, Your Honor, is there's not clarity in the counterclaims on exactly when this supposed decision to replace Cepheid with some of the Jabil product was made, and so I don't know when any such a duty would have arisen. I don't think that the claim is viable for a number of reasons, setting aside the duty to disclose. One of them is the disclaimer of reliance provision. There was some discussion about that before.
Well, the nature of the sale, the circumstances of the sale is certainly something within your knowledge, right? That's what sports tech application seems to suggest, that that's what creates the duty on your part.
Well, I think that's correct as a general matter. The standard appears to be a little bit different in cases like these that involve very sophisticated parties in an arm's length transaction where there's an opportunity to perform diligence. And what the cases say is you have an obligation as a contracting party to protect yourself, to insist on due diligence, to insist on representations and warranties that would address.
Right, but what they argue is there was no level of diligence that would have basically elicited a correct answer from you. Like, what could they have done? Could they have gone, you know, to a public announcement, to some sort of public filing, to something else about what you were going to do with respect to that third-party company?
Well, Your Honor, the minimum obligation I think they had was to ask the question, right. What are the implications for us in this deal? And allowing them to bring a fraud claim when they never even asked that question, as I said before, would be a very dramatic expansion, because a party could always come up with something they wish they had known or some question they wish they had asked in the diligence process. That is not the basis for fraud claim.
It wouldn't be the first time that we allow a fraud claim based on allegations of omission of material facts, right?
Certainly not, and we're not...
We will be changing the law.
We're not suggesting that it... I'm sorry, Your Honor.
That seems to be what sports tech is talking about, right?
Your Honor, we're not suggesting that an omission claim is not viable in general. The problem with this particular omission claim is that they are relying on the special knowledge doctrine as the basis for the duty to disclose. And in order to invoke the special knowledge doctrine, you have to at least first have done some diligence, and you have to have at least attempted to get representations and warranties. I think the Rodas case that I mentioned before is directly on point on that issue. I do want to say just a few words about the misrepresentation claims. We think that they are...
Before you do that, I have another question about the omission claim. I'm looking again at the pages in the record concerning your purchase of Cepheid, and there's nothing about it that suggests that it would make PCBAs or anything else that it was Jabil's contractual right to make. So I don't understand how they would, there's nothing in those 2 pages or a couple of pages that suggest to me that it would have taken over any of the business that Jabil expected to receive under your contract with them.
Well, Your Honor, I don't think it's that specific, but there was information saying that it was going to be an important part of the diagnostic space.
Right, but that doesn't mean in the same, that you would give them the specific business which you had just contracted to do with Jabil.
Your Honor, I think that there is, as I said before, an issue of the timing here. It's not clear that they allege that at the time we put out the press release that we had any sort of intention to replace Jabil's business with Cepheid's business. This claim also has problems with respect to the language of the contract because, as I mentioned before, paragraph 3 gives us the right to outsource to companies like Cepheid the manufacturing of PCBAs, and Jabil fully and freely agreed to that provision. The other relevant provision that they fully and freely agreed to is the disclaimer of reliance provision in paragraph 30 of the MSA, and we would submit that that is certainly a provision that applies to the misrepresentation claims. It applies as well to the omission claims and bars those claims for all the reasons we address in our brief.
So I'm thinking of a very, very homely example, which is that I'm talking to you and I'm talking to you with my hand on the table like this, and I'm just talking to you normally, and you're supposed to ask me what's under my hand.
I think it depends on the context. If we were, in a context where it would be normal to ask that sort of question, then yes. And this is a context where we have 2 very sophisticated parties that hold themselves out as leaders in these industries in the entire world. And so I do think in that circumstance, there is an obligation to do the due diligence. And it's not as though Jabil didn't have the opportunity. These agreements were negotiated over a period of 2 years. There was extensive back and forth discussion, including the exchange of some diligence information. And so if Jabil wanted more diligence information, or if it wanted guarantees that the diligence it was provided was accurate and was reflective of future sales, it could have insisted on that. But instead, it entered into an agreement that does not guarantee it a baseline level of revenue. What it says is there is a projection that you might reach $46 million, but there's no guarantee, and they knew that going into this agreement. Unless there are further questions, we'd ask for...
I think we're good. Thank you, Counsel.
I have just 4 points in response to Mr. McLeod's comments. So Beckman and Danaher's argument seems to be that Jabil simply should have expected them to commit fraud and should have caught them somehow by asking a magic question that would have led them to reveal the fraud. And as we discussed earlier, I just don't see that there is any reason to believe that that would be the case, given that we believe this was in fact a scheme, that we believe this was in fact the Cepheid cannibalization was planned prior to entry into the deals here.
That brings the issue of, inquiry notice. Weren't you at least, and I know this department and the Court of Appeals have buried a lot under that sophisticated parties doctrine. I mean, I don't think it's a sanction to conceal material information. I think Sports Tech talks about that a great deal. But weren't you obligated to at least ask the question? If you knew that there was going to be a sale, at least what does this mean to me before you sign some of the agreements, particularly the project agreements that prevent you from bringing out extra contractual discussions or agreements?
So, and Your Honor, as I mentioned before, I have every reason to believe it was discussed. I simply cannot make that representation standing here in front of you because I do not know with certainty who asked and when. However, the other thing to remember is Danaher is also a huge corporation that makes lots of transactions, acquisitions all of the time. I think to expect Jabil to have tracked that and made sure that it asked questions about every single acquisition. Is this going to impact us? Are you going to do something with this new subsidiary that might harm us? I think that would
But
be
at least minimal inquiry, right? Particularly when you don't know what the nature of that sale was. I mean, you are sophisticated parties. You know what it means to get a third-party company involved.
certainly.
Particularly when there have been specific projections, $46 million, things are going to happen, and they clearly lay it out.
It's certainly, Your Honor. And I would submit, however, that regardless of the level of sophistication, and both Jabel, Beckman, and Danaher, all three are very sophisticated. No matter how sophisticated Jabel is, it's not obligated to be clairvoyant. It doesn't have to read into the hearts and minds of its counterparties, especially when there is something that these folks knew would impact the deal. Now, Mr. McLeod was absolutely right in saying that this was not an exclusive contract. Beckman was certainly allowed to source PCBAs from other manufacturers, and there was no guarantee of $46 million. That, in fact, is one of our main problems with the lower court's decision, as it seems to assume that that's what we were alleging, when in fact we allege the opposite. But the fact that this
This is a dismissal motion, right?
correct, that's right, Your
So
Honor.
if we allow those counterclaims to survive, just at least with respect to the fraudulent omission,
We would go to
that's going to lead to discovery.
correct, that's right, Your
And
Honor.
repleting, hopefully, or at least.
Potentially as well, Your Honor, certainly based on your comments
Okay,
today.
and then we'll see you on summary judgment. I just want to make sure that.
That is the
that's what
posture.
Okay.
Yes, Your Honor. I think what counsel has suggested is that because of the fact that this wasn't an exclusive contract, somehow Beckman would have been allowed to maybe order $1 worth of PCBAs, and that would be perfectly fine under the contract and wouldn't be considered fraudulent, notwithstanding that there were all these representations that led Jabel to reasonably believe, we submit, that $46 million was a reasonable revenue baseline. That simply doesn't fly, Your Honor, and we submit the lower court's decision should be reversed. Thank you all for your time.
Thank you. Great arguments. People versus Rodriguez.
Good afternoon. May it please the court. Nicole Giuglas on behalf of Appellant Mark Rodriguez. Factor 7 on the Board of Examiners Risk Assessment Instrument takes into account a registrant's relationship with the victim at the time of the sexual offense. As the Court of Appeals explained in 2017 in People v. Cook, familial relationships are, quote, specifically excluded by the commentary and by the plain language of the guidelines.
But that doesn't mean we can't take it into account, or that the judge hearing the Sora case can't take it into account, especially in a situation like this, which is so egregious and horrifying.
The Sora court in this case took into account and granted an upward departure based on an incestuous relationship.
On the egregious circumstances of this particular relationship and the sexual abuse that was inflicted on the daughter, wouldn't that be the more accurate description, counsel?
In addition to the threats that were made afterwards in terms of reporting.
That was not the grounds on which the prosecution sought and the court granted an upward departure below. The prosecution specifically, in its submission on pages 3 and 4, noted that it was the gross abuse of familial trust that justified an upward departure.
But isn't gross abuse another way of saying egregious?
A gross abuse of familial trust is not another way of saying egregious, Your Honor. It is instead a way of characterizing as a basis for an upward departure an incestuous relationship.
So that would be up to us to interpret, right? Whether those words equal egregious circumstances in this particular situation. Because what is this, a gross abuse of trust? Is that the language that you're referring to?
That is the language
Okay.
that the people relied on below.
So here, where you have a father raping his daughter, who's 13 years old, who gives birth to a child that he doesn't recognize, would that be a gross abuse of familial trust, counsel?
That was something that, yes, the court found was a gross abuse of familial trust.
And his
yet,
continuing to rape her while she was pregnant, would that be a gross abuse of familial trust?
there was no proof or no evidence that suggested that that was the case. And the Second Department has considered this explicit reason. These cases that the prosecution relied on below have since been reversed by the Second Department because it recognized that an upward departure based on a factor that the board has expressly found is not an aggravating factor is not sufficient for an upward departure.
But it doesn't, our case law, our precedent doesn't, I mean, we're not bound by the Second Department, right? Our precedent allows us to consider an upward departure when the risk assessment instrument does not consider certain parts of the relationship, right? Like, for example, the risk assessment instrument did not consider the incestuous relationship, right? Is there any mention of that in factor 2, 5, and 9? That were the factors that led to the 50 points assessed?
No, Your Honor.
Presumptive.
Factor 7 takes into account the relationship with the victim and finds the opposite of what the prosecution alleged below, that it is not an aggravating factor for risk assessment purposes.
But that doesn't prevent us from finding otherwise under the particular facts of a case where the father's behavior resulted in his daughter giving birth to her sister, essentially.
That would not, if that were the reason that the people sought an upward departure below. That is not the reason that the people relied on below. The people below relied simply on the incestuous nature of the relationship.
But it was the particular incestuous nature. It wasn't just, well, just incest sounds a little strange, but it was in particular incestuous relationship under these facts and circumstances. And that's exactly what we're all talking about.
That was not the way that the prosecution articulated it below, and that was not how the court, even before it made its ruling, articulated what the people were asking.
Did the defendant take responsibility for engaging in this conduct with his 13-year-old daughter?
Yes, he did. He pled before even an indictment was filed. He waived indictment and immediately pled guilty.
He acknowledged paternity, counsel.
I believe so. I'm not sure.
Where in the record is that? I don't believe that he did. He fought any attempt to prove paternity in this case, right?
I don't believe there's any evidence that he fought to prove paternity. There was an ACS investigation at the time that the complainant was initially pregnant, and those documents are separately documents that we opposed being admitted at the SORA hearing because of their unreliability. But there was no evidence in them when they're, even if you accept them into evidence and read them properly, they do not support that he lied or that he fought paternity. There's a note on the first page of the ACS documents, uncredited, it's not clear who wrote it, that simply says that someone determined that a paternity test was not needed at that time. The prosecution, in their submission, misinterpreted that, and then at the SORA hearing, when the court asked them, asked the prosecutor, are you relying on any statements that Mr. Rodriguez allegedly made, the assigned prosecutor expressly answered no.
Let me ask you a different question. What about the victim's handwritten statement that the father said that he would physically hurt her and put her in the hospital if she told anybody, or if he saw the cops coming after him? Would you consider that to be any indicia of an egregious circumstance in this particular relationship?
That would be something that the prosecution could allege. I would argue that that is something that could be taken into account under factor one, were they to allege forcible compulsion by those threats. But again, the prosecution didn't assert that below. Mr. Rodriguez, for purposes of defending at a SORA hearing, which is for risk assessment purposes, is not able to argue against things that the prosecution does not articulate until it's up on appeal.
Okay, thank you, counsel.
May it please the court, Julia Chariot for the respondent, people of the state of New York.
Counsel, does the case law allow for the SORA court to take into account for an upward modification those items that might not be articulated or expressed or accounted for in the risk assessment tool?
Yes, it does. And specifically, this court has allowed the consideration of the incestuous nature of the relationships. And in this particular instance, despite what defendant is claiming now, the prosecution, even in its submissions, was clearly relying on the sum total of the egregious conduct and the egregious nature of this relationship and the fact that he impregnated his daughter. That's mentioned numerous times both in the submission and at the SORA hearing. And that is something that the RAI cannot take into account based on the assessment there, is that not only did he rape his own daughter at the age of 13, he continued to rape her, he watched her carry his child, her sister, to term. When she gave birth, he absolutely did not take responsibility, and we know this because she gave birth in 2013, and because he had threatened her with bodily harm, she did not disclose the paternity because he was not arrested. Had he accepted responsibility, had he acknowledged paternity of the child of his 14-year-old daughter, he would have been brought before the court much sooner. It wasn't until years later, under different circumstances, when she had run away from the home, and this is all in the risk assessment paperwork, she disclosed what had been going on in the household and that he was the father of her child, and a paternity test was done.
And so what is the evidence that he continued to engage in sexual activity during her pregnancy?
In addition to the felony complaint, it is in her DIR that he did this on numerous occasions. The conduct is alleged to have begun in November of 2012. She gave birth in, I believe, July of 2013. Just purely looking at the numbers, he had to have engaged in conduct after she was impregnated. And you know, the complaint actually carries a much longer period of time. There were allegations of 2 years. This was not reached by Justice Bruce. He did not assess any points under that based on the documents that were submitted, but it's clear that there was an ongoing relationship. It was just the time period that was in contest.
Presumably, if defendant had acknowledged paternity in some kind of timely way, that would have been, he would have provided documentation of that as part of his SORA, as part of the SORA hearing to establish his acceptance of responsibility, and there's no such document that he submitted, correct?
Absolutely, Your Honor. And again, it defies logic that he would have acknowledged paternity to ACS or any other party in 2013, and there would have been no repercussions until 2015. It just begs credulity to say that he accepted responsibility. He accepted responsibility after he was caught, after we had the paternity test that proved that he was the father of her child.
Questions?
There being no further questions.
Thank you, counsel.
Thank you, Your Honor.
Very briefly, to clarify on the continuing nature, rather than, as respondent said, Judge Bruce not reaching the decision about whether there was a continuing course of conduct, that was something that was argued and sought by the prosecution below, and Judge Bruce expressly found that there was clear and convincing evidence only supporting 50 points on the risk assessment instrument, thereby finding that there was not clear and convincing evidence, which is the standard that the people are held to, of a continuing course of sexual misconduct. And secondly, The people also below never sought any points for acceptance of responsibility. And in this case, yes, it may be true that Mr. Rodriguez did not affirmatively go to ACS and admit to what he had done wrong, but he did accept responsibility, plead
That was
guilty.
after he'd been caught, right? Not before that. For the first year of the child's life, he didn't accept responsibility, correct? When was it you claim he accepted responsibility? Let's try it that way.
When he was arrested, he immediately, there was no grand jury presentation.
And how old was the child at that point?
I believe the child was about 2 years old.
So for 2 years, he did not accept responsibility. Would you agree with that?
I don't believe that he necessarily knew that the child was his to be able to accept responsibility.
Oh, my.
Wow.
Wow.
That's
Okay.
not a good answer.
Anything else, counsel?
This is a matter that relates to his risk and his future propensity and the need to protect the public. And in this case, the board's assessment as a level 1 was correct, and it should have been affirmed and supported by the SORA court.
So you don't think that the fact that he didn't acknowledge paternity for 2 years after the child was born and only acknowledged it after being caught doesn't suggest that he's a risk in the future?
To the public?
Yes, the public, and any women in it who he chose to act similarly in the way he acted towards his 13-year-old daughter.
I do not believe that it has a bearing on his risk of future reoffense because of the changes that occur in the time after that. I don't believe that the conduct is acceptable or excusable.
What kind of changes occurred, counsel? He was reformed?
He completed sex offender treatment, and he did very well. He completed vocational programs. He completed...
While incarcerated, yes?
Yes, because he was correctly prosecuted and sentenced and served 5 years in prison for the offense. I'm not excusing his conduct, Your Honors. I'm simply speaking to the circumstances that are supposed to be taken into account when predicting future risk of reoffense. And in this case,
counsel.
Thank you.
Thank you. Thank you both. People versus Donay.
I can take this off? It's okay?
You may, yes.
That's really nice. Thanks. It's refreshing. Ben Schatz, may it please the court, for Mr. Donay. The third-degree robbery conviction in this case was against the weight of the evidence. To be guilty of robbery, not only does there have to be a forcible taking, which we concede happened, my client took the cell phone, there has to be a very specific kind of intent, and that is the intent to permanently deprive the complainant of the taken item.
So you're arguing that because the defendant offered to sell the cell phone back to the complainant, there's no indication that he intended to permanently keep it?
Well, we're arguing there is no indication. It's their burden, right? So it's their burden to show proof of intent to permanently deprive. But we're arguing that when you look at, we know a lot about this couple's relationship, right? We know that he came back after a few hours and tried to bargain with the phone. I'm not excusing, it's embarrassing conduct, okay? It's childish, it's really, really embarrassing, and I don't want to minimize anything. This is an abusive relationship, it's bad, there's contempt, and we're not taking issue with contempt. There's a violation of the order of protection. What we're saying is it's not robbery, okay? There is a prior course of conduct between these two men, and there were several instances during that course.
So, counsel, you're saying that the pattern of the abusive relationship negates any intent to permanently deprive, even though the case law would indicate that once the phone is taken and you've left the area, or even if something has been, that is the permanent deprivation?
No, the case law doesn't indicate that, and he didn't leave the area. He runs down the street. No, he runs down the street and then he just hangs out until he can go back up and,
When I say leave the area, I mean like he was no longer in the presence of the complainant with his phone, right? He
Right.
left
right.
with
He
the complainant's
ran down
phone.
the street and stood around and then went back
At
upstairs.
at what point did he offer, because the element is intent to permanently deprive the owner of the property, right?
Right.
So, did he offer to give the phone back at any point upon request?
Yeah, and this is the idea. He went back up and used it as a bargaining chip
For money.
to try
But he
and get
asked
back
for
into the
money.
apartment. Yeah, and
He asked for money, which.
Yeah, and I'm
But that
totally-
indicated that he was treating it as his, not.
no, not at all. And this is very important. This is what the Druin case says in the third department. That is not
Counsel,
intent to
doesn't
Hold on,
the
let him finish
This,
answering.
this is not intent to permanently deprive, even if you're taking it to use for your benefit for a short period of time. That is what Jennings says, the Court of Appeals case. That is what the third department says in Druin. I can give you other sites.
But I'm
That is
talking
not
about the
intent
fact that he tried to
permanently deprive.
sell it back as opposed to give it back.
The idea was he wanted to bargain it back. It wasn't a sale.
That's your
this isn't
Counsel, that's your interpretation, right? Because one could also see it as no money, no phone. I keep it, right?
Yes, but the question is, what is his intent when he takes
Well, let me just ask this question. Isn't that something that's in the jury's purview, how they interpret it, and why should we disturb, the jury didn't believe him, or didn't believe that whatever else scenario other than a permanent deprivation?
It's not a question of credibility at all, because it's what is the evidence that he did intend to permanently take the phone? We have evidence that on several past occasions, when they get in disputes, they interfere with each other's phones. That's what they do. It's ridiculous, but that's what they do. The complainant in this case threw his phone out the window one time, my client's phone. The complainant in this case threw it in the garbage another time. On a previous occasion, my client tried to take the complainant's phone when he was about to call the police, which is exactly what happened in this case.
How do you reconcile what you're saying right now with the Ramos case that this court decided in 2018?
Ramos is completely different than this case. That is a robbery. It looks like a robbery. It's exactly what you think of when you think of a robbery. They go into this apartment and they take something and they leave. This is a dispute between a couple, and he's getting 3.5 to 7 years for taking the phone and running down the street. Well, if there are no further questions, I'll wait till, yes.
I can save it for.
Yeah, go ahead. No.
So I have one concern. When you were describing his conduct earlier, and you said you didn't justify his conduct, it was childish. I'm a little concerned about that. I would have characterized it as abusive, not childish.
Oh, I'll take abusive, absolutely. I don't mean to minimize
I'm
it.
concerned that if there were a woman and fighting with a man, you would not say that the man was acting childishly, you'd say he was acting abusively. And I just want to be clear that we're talking about the same thing here, right?
We're unquestionably talking about the same thing. There's abuse in this relationship. The only thing I was referring to as childish is the inclination of both the complainant and my client to use the phone as a prop in the middle of arguments, which is what happened on previous occasions. That's a compelling inference against a finding of intent, and I'd appreciate if you'd ask my adversary what the evidence is of intent at the moment that he took the phone in light of all that evidence. Thanks.
Thank you. It was up to the jury to examine the conflicting evidence, right? For us to examine the conflicting evidence. But what is the evidence of intent?
Absolutely, Your Honor. This may it please the court, Amanda Regan on behalf of the people. This was a quintessential jury issue, but the evidence of defendant's intent to permanently deprive, I'll just list off quickly. While he was wresting the phone from the victim's hand, defendant repeatedly told him to give me the phone. Once he clawed it from the victim's hand, defendant didn't say anything, and he simply ran away with it and disappeared for up to 3 hours. This is completely unlike the facts of Druin, the third department case that my adversary.
But then he came back, right? And what happened when he came back?
Well, when he comes back, he attempts to use the phone as a bartering chip. He never offers, here's your phone back, let's see if we can reconcile. He just says, give me $30. When the victim doesn't open the door.
So he's assuming ownership by requesting money for it.
Precisely, Your Honor. And when the victim doesn't open the door, he says, all right, give me $20.
Should the pattern of this abusive relationship wherein they might take each other's phones, does that matter in this scenario of permanent?
No, Your Honor, I think there is no comparison. When the defendant is attempting to take the victim's phone from him, it's a violent reaction. The first time, he is choking the victim while simultaneously trying to rip the phone out of his hands. In the robbery count that we're discussing here, he's wrestling him to the ground and violently clawing it from the victim's hands to the point where the victim is bleeding and has scratches all over his hands. Conversely, when the victim interferes with the defendant's phone during an argument, he throws it in the garbage. He throws it out the window. There's no evidence that the phone was even damaged. And the defendant can readily retrieve that phone. Here, the defendant takes the phone after violently clawing it out of the victim's hand, runs away for 3 hours with it, and then only attempts to use it as a bartering chip to get inside the apartment, and actually never actually offers to give the phone back to the victim. And of course,
But just in what you say, he's using it as a bargain to get into the apartment, not to permanently keep the iPhone for his own uses or to sell it to a stranger, right? He's using it as a tool to get back with him, get back in the apartment, either continue the abuse or whatever else.
the relevant time to look at his intent is at the time of the taking. And at the time of the taking, based on what he's saying to the defendant, give me the phone, the fact that he immediately flees and doesn't return for 3 hours, and the fact that unlike the case Drew in the third department case that my adversary relies upon, there's no contemporaneous statement that he doesn't intend to permanently deprive the victim of this phone, that he's just going to use it later on to try to get back into the apartment. He doesn't say a word to the victim. He takes the phone and he runs away with it. That is intent to permanently deprive at that moment, and that is a quintessential jury question that the jury on this record had every right to find that at the moment of the taking, the defendant intended to permanently deprive the victim of the cell phone. And I know that there are a few other issues raised in this case, so unless Your Honors have any questions on those issues, we would ask that you affirm.
Okay, thank you.
Thank you.
Counsel?
Yes.
He got 3.5 to 7 on the third degree robbery, right?
Correct.
And that's to be run concurrently with all the charges, including contempt, right?
Correct. There are 2 contempt charges that he got 2 to 4 on. That's correct.
So how long has he been in?
I know how long until he gets out, and this was since 2019. So it's March 6, 2019 until now, and he has about
So he served more than the minimum of 2, right?
Right. So what we're asking for in our excessive sentence point is run these concurrent. This is what the problem in this case is the contempt problem. The problem isn't a robbery problem. This looks nothing like a robbery. It's a snatching of a phone where he runs down the street in...
Counsel, I have to say that I'm amazed that for me, what you're basically arguing is same old, same old. This is their relationship. They have an abusive relationship. They play back and forth with phones. They play back and forth with phones.
Yes.
And therefore, it never arises to the level where it's a robbery. It never arises to the level where it's a contempt. It really is just the way they interact with each other. And I say no to that. I absolutely say no to that, because the first part of this is we're talking about an abusive relationship which has gone into the criminal realm.
Oh, absolutely. I agree it's in the criminal realm. That's why he was convicted of contempt. We're talking about something completely different here, Your Honor. If we're talking about whether he's using it as a bargaining chip or we're talking about whether he stole it permanently, we're already in the territory of reasonable doubt.
You're using the phone as a bargaining chip with us, and it doesn't work.
There's evidence that that is what they used it for. And when we're in that territory, we're in the territory of reasonable doubt. These are 2 separate counts, and it's felony robbery. That's incredibly serious for the taking of a phone.
I'm confused. If he's using it as a bargaining chip, he must think that he owns it.
I encourage...
How can you bargain with something that you don't have possession and control over?
Because the law says that temporary possession of the kind that you,
It doesn't mean that he has temporary possession if he's using it as a bargaining
this is
chip.
exactly the facts.
If he doesn't get to the agreement he wishes, then he keeps it.
This is the exact facts of this Drew, in case, Your Honor. He says, I'm taking this until you give me what I want, and then I'm giving it back. And the reason we know that was the same here is because that's what they did all the time. It's the same facts, and that is not permanent taking, and that's what the law requires. It's very specific and a
He
very
leaves
high
with
burden.
the phone for 3 hours, right?
Yeah,
We're
correct.
looking at the time of the taking,
Correct.
right? Not at the later time.
That's correct.
And at the time that he takes it, he absconds.
Yes, I mean, he doesn't go in the subway, he doesn't go anywhere, he just hangs around with
He
the phone.
leaves
He leaves the
with
scene.
the phone.
Yes, correct.
He doesn't say, come down the street and I'll give it to you if you kiss me or if you're nice to me or whatever.
That's
takes it.
entirely correct, Your Honor. And
He takes it.
The question here is whether the prosecution proved larcenous intent beyond a reasonable doubt. It is not general intent. It is larcenous intent. It is very specific. It is a requirement that when he took the phone, when he says, give me the phone,
He intended to permanently deprive
he
him
meant,
of
I'm
it.
keeping it. Give me the phone, I'm keeping
Rather
it.
than come
We
back.
know that's not what he wanted to get back in the apartment. We know that's what he wanted to do. He lived there, and he was locked out. Thank you.
Thank you. Thank you both. Okay. People versus, oh, that was People versus Donay, sorry.
Ortiz versus Maxim.
Yeah, so, to Ortiz versus Maxim.
Good afternoon, and may it please the court. Jeffrey Present on behalf of the appellant. I would respectfully submit to the panel that the underlying motion didn't eliminate all tribal issues of fact here, but rather highlighted them. The motion papers annexed, among other things, my client, the appellant's deposition transcript. In that transcript, there were multiple instances for the court to have found a tribal issue in connection to the three-vehicle car accident, particularly my client's testimony that the respondent admitted that the respondent's vehicle struck the plaintiff's vehicle prior to the time within which my client's vehicle struck the respondent's car. That's part of the showing of the respondent as movement in the underlying motion papers. That on its own merits denial of the motion. The brief that was submitted by the respondent initially states, number one, that my client's not an aggrieved party. I think that
Well, you have a right to contribution, so forget that.
And that was the initial point that was made. The second point that was made basically states that my client was not credible. And I believe Judge Pitt made a mention of that a couple of cases ago, saying, well, isn't that for the jury to look into and not the motion court? I think in this case, it really jumps out at one to say, it's not our job as counsel or even the motion judge to say who's credible and who's not credible. If there's contrary testimony, and that's in the motion in chief, annexed therein, I don't see how there isn't a triable issue with all due respect.
So I have a question.
Yes, Your Honor.
So we know that this is a three-car collision, right?
Yes, Judge.
And we also know that the airbags deployed in the middle car,
The respondent's car, yes.
right? How does that factor into your argument?
If you want to look at inferences, my client testified that the impact between his vehicle and the respondent's was secondary and minimal. The impact between the respondent's vehicle and the plaintiff's car was of a nature that airbag went off, and that's backed up by the respondent's testimony that he was driving at 50 miles an hour when he was 10 to 15 feet from the plaintiff's car. And allegedly, when my client struck the respondent in the rear, was 5 feet away from the plaintiff's car and traveling at 20 miles an hour. And my experience would be that almost every judge in the state would take judicial notice that A vehicle that's traveling at 20 miles per hour is traveling at 30 feet per second. So on that basis, there's a very strong inference that the respondent would never have been able to have avoided contact with the plaintiff without any mention of what happened behind the respondent's vehicle. And that's what the motion papers, among other things, tried to demonstrate, that that testimony certainly would be rather strenuous in favor of the idea that the respondent caused the accident before there was any contact between my client and the
So the
respondent.
airbags for you, just by themselves, presented questions of fact?
I think that plus the testimony about speed would certainly lead to an inference, Your Honor.
Thank you, counsel.
Thank you very much, Your Honor.
Good afternoon, Your Honors. May it please the Court. Irina Kravchenko, I represent defendants' respondents on this appeal. It is the respondents' contention that the Supreme Court correctly granted their motion and dismissed all claims against them. Contrary to opposing counsel's assertions, there are no evidence other than speculation that Mr. Garmais came into contact with plaintiff first before he was pushed into that car by defendant Maxon.
Well, the testimony from the third car, Mr. Garmais, he says that he observed the second vehicle shake prior to his impact, correct? Wouldn't that testimony at least raise a question of fact? It's conflicting to the other testimony, or the other position, rather.
Your Honor, it is the respondent's position that it does not. While defendant Maxon indicated that he heard a bang and saw my client's car shake, he expressly testified that he didn't actually know if it shook forward or backwards. He also repeatedly, on at least 3 occasions, indicated that, and I quote, "I did not see in front of Mr. Garmais' my client's vehicle." He expressly indicated that he had no idea what actually happened in front of Mr. Garmais' car. In fact, in order to excuse his admission to the police officer, then yes, defendant Maxon actually rear-ended my client first, which, by the way, defendant Maxon never flat out denied. He said he didn't recall, but he attempted to justify that admission by saying that I couldn't have said that I hit him first because I couldn't see in front of his car. So the same exact analysis applies.
But he heard a bang, right?
Yes, he heard a bang, but he had no idea where it was coming from. The jury would have to speculate to conclude that it came from the impact between my driver's vehicle and plaintiff's, because based on defendant Maxon's testimony, there is no evidence to conclude that. He did not see.
The car number 1, the plaintiff indicated that he felt 1 bump, not 2, right?
Correct.
So how does that factor into your argument?
Your Honor, that actually supports the respondent's position that the impact caused by defendant Maxon pushed Mr. Garmais' vehicle into plaintiff. It's in line with that theory that that's exactly what occurred, and that's the only evidence that that is in fact what occurred. With respect to opposing counsel's statements as to this purported admission that Mr. Garmais made to him on the scene, the record simply does not support this. There's extensive questions and answers on this point on pages 193 and 194, where plaintiff's counsel asked the defendant Maxon no less than 4 times to tell him specifically, "I just want to be clear," and I quote, "that the driver of the car that was directly in front of you tell you that he hit the car that was in front of him before you hit his car." Defendant Maxon repeatedly, ambiguously stated, "I recall that conversation." Is that what he said to you? "I recall that conversation." He said that at least 5 times. It is clear that there was no admission made. He was attempting to make an implication that that's what had occurred without actually lying on the record. That testimony that does not actually implicitly, flat out refuses to indicate that the admission was made, and certainly not enough to raise a question of fact based on the admission. And lastly, I would just like to address the counsel's argument with respect to the airbags and the distances and the speed, et cetera. That's entirely based on speculation. That's why the Supreme Court correctly disregarded it. There is absolutely no expert evidence that was submitted by defendant Maxon to show that the deployment wouldn't have occurred had the impacts were in a different collision. There's no evidence in the record to raise a question of fact on this issue without an expert actually making findings on this point.
Counsel, you're asking us to rely in part on the police report, correct?
Your Honor, the police report is in the record, and it is.
Are you asking us to rely on it?
Yes, it is our position that the bench should rely on it.
Even though it's uncertified?
Your Honor, yes, because as hearsay can be used as an additional evidence. In this case, it just shows defendant Maxon's admissions on the scene.
You acknowledge it's hearsay?
I acknowledge that the actual report was not certified, but there's other evidence that is more direct that actually establishes Mr. Garmise's lack of liability.
Thank you.
Thank you.
Don't mind me standing
Oh,
up.
of course, Your Honor. I would just note, with respect to the police report, it's the appellant's position there is no declaration against interest and there is no party admission aside from the certification. Any reference to it is inappropriate, I would submit. The respondent did not address the issue as to the admission that the respondent relayed to my client, the appellant at the scene, that the sequence of the events was first that the respondent struck the plaintiff, and only thereafter, my client struck the rear of the respondent's vehicle. That's within the record, and that's within the respondent's motion papers. So as far as I would imagine, that on its own creates a tribal issue because that was in the case in chief of the initial motion. The sequence of events, I think there's a very decided tribal issue that Justice Headley didn't reconcile. Justice Headley also noted that the sequence of events was uncontroverted. And I would respectfully submit that based on the papers, that's not the case, that there's a very decided issue, and that the respondent essentially admits that the police report has no bearing on this, shouldn't be considered. And if you look at this in the light most favorable to the non-moving party, the appellant, the underlying order should respectfully be reversed. With that, I thank you all very much. And
Thank you,
our brief.
Ramirez versus Moab Capital.
Good afternoon, Your Honors, and may it please the Court. Mark S. Pincus from Gardner Skelton, PLLC, for Defendant Appellant, Moab Capital Partners, LLC. This Court should reverse the trial court's decision and dismiss plaintiffs' 2018 bonus claims because they failed to state a cause of action under CPLR 3211A7. Plaintiffs' 2018 bonus claims are nearly 94% of the purported value of plaintiff's case, and plaintiff cannot pursue them because the record before this Court shows that plaintiff waived his right to challenge.
Now, are you claiming that when he said thank you to your client's offer to give him something instead of nothing, that was a waiver of his claim to the full amount of the bonus?
No, Your Honor, that's only part of the record. The record...
So let's
well, I didn't go into every word, but I mean, that's sort of the sequence of events, is that your client thanked him for giving him something, and you're saying that's a waiver?
Well, Your Honor, it's not just that he thanked them, it's also what the record shows he did for 2 years afterward. What happened was that...
So, counsel, before you...
No, let him answer it. Let him answer it.
Your Honor,
Finish your answer.
What happened is that December 21st, 2018, plaintiff meets with the president of Moab, Michael Rothenberg, and Mr. Rothenberg says that Moab's decision was that, based on the numbers, Mr. Ramirez, the plaintiff, had not earned a 2018 bonus, but that Moab would give him $60,000 discretionary bonus anyway. For 3 days after that, Mr. Ramirez protested, both to Mr. Rothenberg and also to Mr. Goldstein, who was the CFO, saying that Moab should not have counted his 2017 losses into the calculation, and he asked for more. After 3 days and multiple meetings, Moab still wouldn't change his position. But December 24th, 2018, in the afternoon, there was a
Christmas Eve, right?
Conversation, Christmas Eve. There was a Bloomberg conversation where Moab made its first concession and said that they would give him an $85,000 bonus, which was up $25,000 from the original $60,000 discretionary bonus, and also that they would wipe the slate clean for 2019, meaning that they wouldn't count the old losses from 2017 into the formula for all.
So what about the, before Justice Gonzalez asks her question, what about the 2 years you were referring to? How does that create a waiver?
So what happened was, instead of protesting, now his public position reverses course.
What do you mean protesting? I mean, he thanked them?
He was, in the beginning, he was saying, you have to pay me more, miscalculated the formula, and then after the 3 days, and when Mr. Rothenberg offered and said that he would give him an extra $25,000 and wouldn't count the old losses going forward, instead of continuing to protest, what Mr. Ramirez said in response to the increased money was, quote, "Got it, thank you very, very much. I really appreciate it." And then
Right.
after...
So that the temerity of
Right, he
being
went from-
professional and dealing with the issue like an adult rather than
Well, he
curse
didn't...
him out for giving him less than.
Well, it wasn't, he didn't ask for more after that. He accepted the $85,000. He accepted wiping the slate
And then he had a few years.
And then for 2 years, the record shows that he said nothing. We brought this up in
So
the
what?
motion
So what?
below.
So what?
Well,
He said nothing.
the issue
How
is-
long does he have to sue under the contract?
But no reasonable person in Moab's position would believe, based on his accepting it, saying thank you, and then nothing happening for 2 years, that he still intended to press the claims. There was another bonus
But the
cycle
thing about that,
in there.
sorry.
It was only when he was
No.
laid off. Your Honor.
He has more than 2 years to begin his lawsuit, right? There's no initial element of being unprofessional and nasty in response to money being offered that is less than what he feels he's entitled to. I know that a childish response will be to curse your client out and demand more and continue to engage in a battle over money that he's entitled to, or an adult professional will take the time to get a lawyer, make sure that he has all the ducks in a row, and then the statute of limitation on a contract claim is several years, certainly
But-
more than 2, right?
Your Honor, when you're talking about, it's not just about being childish. It's his behavior was professional, but the point was that he accepted what was given to him after 3 days of disputing it, and then for 2 years thereafter, he said nothing. Any
Did he
reasonable person in
sign,
Moab-
did he sign anything? Did he sign a waiver?
Did he sign a waiver? No, there was nothing that was signed. But,
And did your client even ask him to sign a waiver?
well, my client didn't ask him to sign a waiver, but any reasonable person in Moab's position would think that this was no longer an issue, that it had been
But
resolved.
isn't the
Mo-
issue,
a corporation that would think that?
isn't the issue of the waiver at least something that goes beyond this 3211 motion, right? You're stating these factual things that need to be proven.
Well, the Court of Appeals said in Connaughton that dismissal is warranted when the facts don't support an enforceable right of recovery. There's nothing else here. When we brought this issue up of him saying nothing for 2 years, in response to our motion to dismiss below.
Well, what about the employment contract itself? Does it permit a loss to be carried forward as your client did?
Well, that's our position, and that will be
As a
litigated
matter
if
of law.
if
Now, I
this court
understand
doesn't
that's your
reverse, but
position, you want us to find, as a matter of law, that notwithstanding the fact that it's not in the contract, that we should nevertheless prevent him from suing.
the answer is that regardless of what is in the contract, his behavior and his words demonstrate waiver that he no longer intended to pursue the claim.
Well,
No, you asked my question about the employment
Oh,
contract.
okay. Anja?
Did your client take any acts in reliance on what you're saying his behavior was?
Well, he
Did it
paid
change
him-
its position? Did it suffer a loss of any kind?
Well, his position was that $60,000.
No, the way you're arguing this, it's as if your client relied upon his behavior. Did your client take any acts in reliance? Did he change his position? Did your client suffer any losses because of its assumption that everything was okay?
Well, on this record, he paid him the money. He also didn't
No,
calculate the losses.
he paid him
going
the amount of money that he felt like paying.
Well, he paid,
right?
it was his
And
position
you
that...
want us to take that partial, the $25,000 as a knowing voluntary abandonment of his rights under the contract. That's what you want us to find.
Well, based on that, plus the 2 years, it shows that he had no intention. There was another bonus cycle. He never brought it up. That's in the record,
So
too.
statute of limitations have no meaning under a breach, He had 3 or 6 years, I haven't checked.
Well,
3, right? 3 years.
6 on a
6 years, right, on the contract.
Your Honor, it was
Statute
his...
of limitation is 6 years on a contract. He spends 2 years lining up counsel and getting ready to sue. And you're saying that the fact that he didn't do it that he did it within the 6-year period he's entitled to, that's a knowing voluntary abandonment of his rights under the contract.
Well, I'm saying that for the 2 years for saying nothing after protesting for 3 days and being adamant that he was entitled to more and then accepting what Moab had, had conceded in
Maybe he thought
further
your
response.
client was intent on violating the contract and there was nothing else he could do about it. And rather than being unprofessional, he just let it go and decided he wanted to go to court. It's not like he was in a nice bargaining position, right? Your client is in the driver's seat.
He stayed with the company. He was there, went through more bonus cycles.
Right.
Nobody.
He didn't want to be out of a job, especially during Christmas Eve. Imagine if on the 24th of December, he decides to be nasty to your client, who he feels already denied him the rights under the contract. What do you think your client would have done? I think a reasonable person would assume your client would have probably fired him on the spot. So he decided, let me be professional, let me be something cordial and thank him for the $25,000 that he gave me. That's not an acceptance or a waiver, is it?
In our view, Your Honor, just his actions and what he said, plus the 2 years, extra bonus cycles, that demonstrates a waiver and no further discovery is needed.
Okay. Thank you, counsel.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court, my name is David Greenberger on behalf of Mr. Omari Ramirez. I will attempt to be brief, but there are 4 points I want to make to follow up on some of the thoughts that the justices had. First, we just heard it. The position that Moab takes on this appeal is that Moab, reasonably believed that there was a waiver. That's not the standard. That's not the case law. What the case law says, Jeff Paul, fundamental portfolio advisors, is that it is an issue of the plaintiff's intent. What did the plaintiff mean? What was the plaintiff thinking? Was it, to His Honor's point, a knowing, voluntary, and intentional abandonment?
Well, you waited 2 years.
We have 6. This is the state of New York. And to Your Honor's point, why did he write on record page 39? Why did he write, "Thank you very, very much"? Was it because he thought that that was the right professional thing to do? That he had a young child at home and he might get fired if he pushed it any further? Did he think that they were awarding him a discretionary bonus, which is what they concede they did, as opposed to the formulaic bonus compensation pursuant to the employment agreement, and say, okay, I'll deal with this another day. Let me go home. Or maybe there was something else. We don't know, because this is a pleading stage, and we have the right to discovery. They have the right to discovery. But what they can't do is they can't get up before a court and say, oh, there's a Bloomberg instant message session chat between 2 people where someone says, thank you very much, and therefore they've waived all of their legal claims. That would turn this entire court system upside down. Anytime someone's nice, they've waived a claim. No one wants that. Be a professional. As His Honor said, go see a lawyer, deal with it in another day. That's another point I wanted to make is Judge Borak below found with respect to 32A1 that the Bloomberg IM chat, and I quote, does not utterly refute the claim. If that is the case, how can the same document constitute a basis to dismiss a claim for 32A7 ground? The standard there is that it has to conclusively establish that there's no cause of action. Judge Borak said it doesn't utterly refute the claim. Moab didn't appeal that. Of their own volition, they didn't appeal that. They said that was right, that's accurate. And yet now they come before you and they say that the same document, the same one, is a basis for us to overturn the lower court's decision on 32A7 grounds. It's folly. That's the only word I can think of. It's complete folly. Finally, I want to just be clear, waiver is not lightly presumed. They recognize that. Judge Borak recognized that. I'm sure this court recognizes it. It's a question of fact. It's usually a question of fact for a trial. I have no doubt we'll be back here on summary judgment. We'll probably be back after a trial. Let's deal with it then. This is not the appropriate time to be dealing with these issues. On a motion to dismiss, 32A7, Mr. Ramirez is afforded every possible inference, unless there's something that is so conclusive that he can't state a cause of action. Thank you very much. Doesn't do it. Unless the court has any further questions for me, I'll rest on my brief, and I thank the court for its
I
attention.
think we're good, Counsel.
Thank you very much.
Just make a couple of brief points in rebuttal. Mr. Greenberger was talking about his client's state of mind. When you're deciding waiver is a matter of law, it doesn't matter what the plaintiff privately thought, but rather what he publicly said.
Oh, but it's not his burden to prove what his intent was. You have to, the burden, we have to interpret we have to look at the four corners of the complaint, is what the case law says, right? And then determine, I mean, basically you want a ruling as a matter of law on what are in fact factual questions regarding his intent and everything else. You want us to find waiver.
But the record, it's our position that the record demonstrates waiver is a matter of law, and therefore the plaintiff's state of mind is irrelevant. Additionally, I just want to make one other procedural point. There are cases, including the Metro Search case, that say that when a complaint makes reference to a document but doesn't attach it, that document is incorporated into the record. The standard of whether the document utterly refutes the allegations is not applicable here, A, because we did not put our appeal forward on 3211A1, but also because since it's 3211A7, the Bloomberg chat is part of the record, and it's fair game for this court to decide the motion to dismiss and include it regardless of whether it utterly refutes the allegations in the complaint. I have nothing further, Your Honors, unless Your Honors have anything further for me.
Thank you both.
Thank you, Your Honors.
Last, Clark versus Boyle. Justice Gonzalez has recused in this matter.
Good afternoon, Your Honors. May it please the court. My name is David Cohn, and I represent the petitioner in this case, Darcel Clark, the District Attorney of Bronx County. I would like to begin by noting what is undisputed in this case. It is undisputed that the defendant was a leader of a gang assault and robbery.
Actually, I have a question about that.
Yes, Judge.
You said in your reply brief that the defendant does not dispute that he was a ringleader of the gang assault. I didn't see any evidence either that he was the ringleader or that he did not dispute it. And a related question is, and this is important in terms of what's in the record before Judge Boyle was only the transcript of the retention hearing. Your office chose not to put in the grand jury minutes, and the retention hearing was a fairly brief hearing. So shouldn't we be only relying on the retention hearing minutes and not anything else?
Well, Your Honor, when it comes to Judge Boyle's decision, we are not taking issue with any of his factual findings. We do have an argument in our papers that under the statute, the judge is required to consider the accusatory instrument as well as anything that the parties submit. The accusatory instrument here is an indictment. Indictment is obviously based on the grand jury minutes. So the grand jury minutes
suggesting that the judge should have gone and looked up the grand jury minutes even though you didn't offer them?
Your Honor, that's what the statute appears to say. But beyond that, we do not take issue with any of Judge Boyle's factual findings. Justice Boyle said, in his opinion, that the defendant was a principal actor in this attack.
Right.
So that is beyond dispute for the purposes of this appeal, that the defendant was a principal actor.
Principal actor is different from a ringleader, right?
I don't know, Your Honor, whether there is a difference there. It's clear from the record in this case that the defendant chased down, tackled the victim, kicked and punched him, and was the person who pushed him onto the subway tracks. Right? So that is, given Judge Boyle, even Judge Boyle's decision, taking his factual findings, That is undisputed in this case, in this appeal. Of course, if there's a trial, then those facts could be disputed, but for the purposes of this appeal, that is undisputed. It is undisputed also in this appeal that under the settled principles of causation that apply throughout the criminal law, the defendant caused significant physical injury to the surviving victim who suffered a broken elbow which required surgery, and he also caused the death of the bystander who jumped onto the tracks.
Yeah. Counsel, I don't want you to spend all of your time on that. Let's assume for the moment that the trial court was incorrect in finding that the defendant caused or did not cause significant physical injury. The question that I have is, what do we do then?
Well,
can we decide this issue on a writ of prohibition?
Your Honor, the case law says that you can, and I believe that the matter of Clark v. Neubauer is very instructive in that matter. What Clark v. Neubauer and Holtzman v. Goldman, which are cited in our papers, set out is there are three prongs that must be met for this court to grant Article 78 relief. First, there must be a clear error of law. Second, the court's ruling must have terminated the criminal action. And third, the people must have no other avenue for review. All three of those prongs are met here.
Tell me what the clear legal right for the prosecution to be sent back to Supreme Court.
Right. The clear legal error here, Your Honor, is that Justice Boyle read words into the statute that do not exist. Justice Boyle said that the defendant had to be the quote-unquote direct cause of the injury and made up his own definition of what direct cause meant, which violates the principles of causation which have been laid down for...
Was there some sort of direction from the legislative history in this case that would indicate that the direct cause, meaning being the sole actor, maybe was that part of Judge Boyle's reasoning?
Well, Your Honor, that was Justice Boyle's reasoning, but we submit, Your Honor, that Justice Boyle read the legislative history incorrectly, and even if he didn't...
Well, let's assume that he did, and this is why I asked you the question. I mean, haven't we found that a writ of prohibition is unavailable to correct legal errors?
In Clark v. Neubauer, Your Honor, what the judge did in that case was rule that under collateral estoppel principles, that's a legal determination of collateral estoppel, that the people could not present evidence that proved the element of force for the top charge of the indictment, robbery 3. There was no avenue for review by the people of that decision. This court held in Clark v. Neubauer that because of that legal ruling, which was clear legal error, and there was no avenue for review, and it terminated the people's ability to bring the criminal charge in the criminal court, that justified the issuance of a writ of prohibition. In Holtzman v. Goldman, the Court of Appeals did the same thing. That was a case in which the judge made a legal ruling, ruled for a trial order of dismissal on behalf of the defendant. It was a ruling that was outside the court's authority to make under the law. And the Court of Appeals said because that terminated the criminal action and because there was no avenue for review by the people, then the writ of prohibition was appropriate. What this court and the Court of Appeals has said is that if there is a ruling by the judge which goes beyond the judge's authority to terminate a criminal action, that is one of the rare, unusual circumstances.
But that is different than legal error, right? So for example, in Johnson v. Price, we found that an error made in the sentence application or applying an incorrect burden, although a legal error wasn't sufficient to find for a writ of mandamus to lie under those circumstances.
Yes, Justice. Yes, and that is correct. And there is another distinguishing factor in the matter of Johnson v. Price. In that case, the criminal action wasn't terminated. It is true that the court imposed an improper burden of proof at the sentencing proceeding on the people. But that did not terminate the criminal action. It didn't even terminate the people's right to seek the sentence that they desire. And this is a different situation because it terminated the criminal action. Clark v. Neubauer It is more like this case than like Johnson v. Price, because in Clark v. Neubauer, the criminal action was terminated. In Holtzman v. Goldman, the criminal action was terminated. The cases that are cited by the defendant are cases in which the criminal action was not terminated. There might have been another legally erroneous ruling made by the judge, but did not deny the people their right to pursue a charge in criminal court. That is what happened here. The judge acted outside of his authority by adding words to a statute that did not exist, violated long-standing principles of criminal law about the meaning of causation. The legislature used the same word in the Raise the Aid statute, caused, that it used to say a defendant's guilty of manslaughter if he causes the death of an intended victim or a third person when intending to cause serious physical injury.
But he changed the standard. I said significant physical injury rather than just physical injury.
Right, Your Honor, but the word caused is the same. The only difference is the nature of the injury that has to be caused, right? So significant physical injury is not a criminal law concept. That's a civil.
So they were not interested in a kid involved in a fist fight, you know, whether that case is in Supreme or family. That's not the concern.
Right.
The concern is when a serious crime is being committed.
Exactly, Your Honor, and that's why they wanted the injury to be significant, importing tort law principles. And as Justice Boyle found, the broken elbow qualifies as significant injury, and certainly the death of the Good Samaritan qualifies as significant injury as well.
Counsel, I'm sorry, I just have one question. If the legislature had intended for an avenue for the people to, I guess, appeal the decision of, or the discretion of the trial court in removing the case to family court, wouldn't they have put that inside the statute? Wouldn't they have allowed some avenue? Because you're saying there's no other way other than this writ. Wouldn't the legislature have covered that, or is that something they missed?
Well, the legislature has authorized this writ as well. So the legislature did not authorize an appeal, that is true, but the legislature didn't authorize an appeal in Clark v. Neubauer or in Holtzman v. Goldman either. And the courts in those cases set out a test for when the writ of prohibition, which is authorized under CPLR Article 78, for when that can be issued. And under the circumstances of this case, the three prongs have been met, and the writ can be issued. It's important in this case for this court to speak on this issue because there is a lack of clarity in the law, as has been demonstrated by the conflicting opinions from the lower courts, which are cited in the papers. This is a very important area of the law, and as Justice Acosta noted, these are substantial crimes. These are significant crimes where people have suffered significant injuries. And the legislature has spoken that it wants these cases retained in Supreme Court. And it's important that this court give guidance to the lower courts on what the legal standard of causation is, so that they can follow the law and apply it correctly.
Thank you.
Thank you, Your Honor.
No, hold on.
I have one more
Sorry,
question.
Judge.
Is it your position that if the prosecution proves one of the factors listed in 72223 subdivision 2C1, that the judge is required to keep it in Supreme Court?
Yes, Your Honor, that's what the...
How do you get that from the, it seems to me that what the statute says is that if the prosecution doesn't prove any of those facts, then the trial judge must send it to family court. But it doesn't say if the trial judge finds those facts, whether he must do one thing or another. It just doesn't say.
Yeah.
So why doesn't that,
Yeah.
why, the failure to say that he must do one thing or the other, doesn't that suggest that he has discretion at that point?
Justice Ginsburg, that's not how the statute reads. And let me explain the...
Tell me where,
Yeah.
I've read it several times. I have
Yeah.
it right here.
Let me explain how the statute sets this up, and there are two prongs.
I know how
right?
it sets it up.
So first, if the felony is not a violent felony or a Class A non-drug felony, then the presumption is for removal to federal court. That's subdivision 1 of the statute. And it talks about, if there is a non-drug Class A felony or a violent felony as defined in the penal law, there has to be the 6-day retention hearing. And then once that 6-day at that 6-day retention hearing, the judge evaluates the submissions, evaluates the accusatory instrument, and then looks for one of 3 factors. The one here is significant physical injury to a non-participant in the offense. Another factor is the use of a firearm.
Gone, right.
Right, so there are three
A
factors.
sexual
Yes, and
intercourse on the 130.
yes, Your Honor, right, exactly. And the statute is very clear that if one of those three factors is met, and if there's a violent felony charge or a Class A homicide charge, if one of those three factors is met, then the action must be retained in Supreme
Where
Court.
does it say that? I don't see that it says must.
Well, if-
I'm looking at the statute,
It-
and it says.
It says shall be retained.
It says it shall.
Shall be
Court
retained,
shall
right?
order the action to proceed in accordance.
Well, 722.20.
Unless, after reviewing the paper, the court determines in writing that the district attorney proved by a preponderance of the evidence one or more of the following. But it doesn't say that what the court must do if it makes that finding. Maybe I'm missing it. Could you show me where it says
Yeah,
that?
Your Honor, let me pull that up. I do have the statute.
It's 722.23(1)D.
Yeah.
Says that the court shall deny the motion, I think after that 6-day period that you were talking about.
Right, so 722.20, exactly. And let me, I apologize, Your Honor, I'm just pulling this up, right? But I ask the court to please engage with the statute because the defense also doesn't dispute our reading of the statute.
Counsel, I'm engaging with the statute.
Yes.
I'm trying to find
Yeah.
where in the statute it says that if the court makes those findings, it must hold it and hold the case and not
Okay.
send it to family court. I don't see that, and I may have missed it. I'm sure you're more familiar with the statute than I am, but I don't see that, and I'd really appreciate it if you could show me where it is.
Yes.
Okay,
Yes, Your
I mean,
Honor.
I'll give you, what, you have a few minutes rebuttal. I'll give you the opportunity to respond to that. Let me hear from the
Okay,
other side.
Your Honor, thank you.
Okay. This is more complicated.
Good afternoon, and may it please the court. Stephen Benethan of the Bronx Defenders, appearing for Respondent BG. Your Honors, a holding in favor of the people today would mean that any time the prosecution disagrees with a trial judge's application of the plain language of a statute to the facts before the court, and the people don't otherwise have an appeal under the criminal procedure law, they can bring a writ of prohibition or a declaratory judgment action.
So you think a writ of prohibition is just an improper way around the legislature policy choice not to give the prosecution a right to appeal?
Exactly, Your Honor. And that's really what the people are doing here. And I have to say, Your Honors, look at today's calendar. This is an original special proceeding in the court. This is not an appeal. And my adversary got up and essentially had an appellate argument with you about whether Justice Boyle correctly applied the language of the statute to the facts.
So are you saying that they have no remedy?
Well, Your Honor, I think what I'm saying is more complicated and more nuanced than that. As the law stands under the criminal procedure law, yes, the people cannot bring an interlocutory appeal from an order of a youth part justice.
I'm sorry. Go ahead.
So you're answering my question in the affirmative. They have no remedy.
They have no remedy, but they have no remedy in this court. They can seek to have the statute modified. And I will,
So they can make a motion to prevent the removal of the case, right?
well, they can certainly do that. And the other thing I guess I would stress, Your Honors, is that, when we point this out on page 9, footnote 2 of our memorandum of law and our verified answer, the people have obtained a legislative addition to CPL 45020 in subsection 12, which addresses discovery sanctions under the newly enacted Criminal Procedure Article 245. So what happened there, for instance? We had a new law, and let's step back and think about the landscape of
Let's
our...
be serious here. We're not talking about what's going to happen in 3 or 4 years after the people try to change the statute with the legislature. Let's confine ourselves to the facts that we have and the case that we have.
Yes.
What you're arguing here is that the people have no remedy in this case.
Yes, Your Honor, and I would say, though, this is not inconsistent with other aspects of criminal proceedings. I note Justice Pitt raised the point before, perhaps the legislature intended that the people not have an appeal from these types of orders. And what would that mean, right? That would mean interrupting the removal of a matter from Supreme Court to family court, where at the end of the day, this young person is being prosecuted either way. This is a decision about where they will be prosecuted. That means interrupting the proceedings.
I'm sorry.
No, no. I mean, where they prosecute, I mean, family court is different. I mean, that's why on the 722.23(1)D, that's where, you know, to prevent the removal, once the motion is made by the district attorney, the court has to deny the motion unless it finds what? It finds that, in this case, extraordinary circumstances exist that should prevent the transfer from family court. And one of those circumstances, they argue, and this is why they argue that Justice Boyle was wrong, is in determining what significant physical injury means, right?
Well, the issue, though, Your Honor, is I think going back to Johnson versus Price, right? What we have here is Justice Boyle looked at the plain language of the statute. In an extensive opinion, he cited the legislative history, and he concluded this wasn't made out. He did what judges do every day. They look at the statute, they look at the legislative history, they look at the facts before the court. What I will say, well, I'll say 2 points further, is first, there are plenty of other aspects of criminal proceedings where there's a significant decision made and the people don't have an appeal. Let's consider in the misdemeanor context, the court determines a complaint is not converted to an information. The people can't take an appeal, and that has serious consequences for them.
I mean, there's no interlocutory appeals in criminal proceedings generally, right?
Right, and this goes back to my point that I opened on, concluding in this circumstance where all that is at issue is a court's application of the language of a statute to the facts before it. Concluding that grants the people a writ. That means the people can have a writ whenever they don't have an appeal, and a writ is an extraordinary remedy. It means the people can pepper already overburdened criminal courts and their justices and indigent defense providers like myself with endless original proceedings in this court, which is probably not what our legislature intended. And I'll just say 2 additional points on that, which is, if your honors have pause, if your honors feel perhaps the people should have this appeal by statute, certainly this court is no stranger to expressing in a decision. Perhaps a legislature should consider something seriously on this issue. I'll note, Presiding Justice Acosta, your decision in Scavetta v. Wexler is an excellent example where the court said, look, we are bound by Court of Appeals precedent, but we urge the Court of Appeals to revisit this. Certainly the court can express that view, but this is taking an exceptional remedy and turning it on its head to get an interlocutory appeal that does not exist. If there are no further questions from the court, I will rest on my papers. I ask that the petition be denied and dismissed.
I want to ask, I'd like to ask you the same question I asked counsel. Is it your position that if the prosecutor shows the facts set out in subdivision 2C1, that the youth part must keep the case in Supreme Court, or does the youth part judge have discretion in those circumstances? Was that not clear?
No, it's clear. It's just not easy.
I do believe the purpose of the retention hearing, though, is that there is actually, generally there's a presumption of removal, but I think when it is a felony of this nature, the presumption is complicated to articulate.
In other words, once they've gone through the retention hearing and they find that the factors have been met in the statutes to prevent the removal, does the court then have the ability to say, well, I'm going to send it to family court anyway, or do they have to keep it in Supreme Court?
Right, because the way that I read it is the youth part must remove a prosecution to family court. The presumption is that it's going to go to family court given the age of the defendant, right? And unless the court grants the people's motion to prevent the removal. So they do have a remedy at the lower level to try to to prevent the removal to family court. And that's on the 722.23(1)D. And that's where the statute then says, but the court has to deny, shall deny the motion unless the court finds this extraordinary circumstance.
Right, and Your Honor, I guess, I apologize, Justice
But
Ginsburg.
the question is, if it finds those things, is it required to keep it and not permitted to send it to family court? Or does it still have discretion?
If he finds extraordinary
If
circumstances?
it finds the circumstances listed in
Yeah, I think
subdivision
shall
2C.
deny means no discretion.
They shall deny the removal.
I do believe under these circumstances, yes, the general presumption is removal for an offense of this nature if the people prove one of the factors at the retention hearing, the matter is staying in Supreme Court. It is. But I will just say to Justice Acosta's point, I think what we see here is that the people first didn't prevail at the retention hearing and then attempted to make an extraordinary circumstances showing and didn't succeed again. I think that goes to Your Honor's point that that is also
So they
a
made
built-in
their
remedy.
motion and they went through the remedy that was provided by the legislature. Now they're trying to use the writ of prohibition to get around, to create a right to an appeal right.
Right, and that's the crux of our argument, Your Honor, is there's no interlocutory appeal here, and this extraordinary remedy can't be turned on its head to create one.
Thank you, counsel. So you got a couple of minutes to answer that question.
Thank you, Your Honors. And I realize it's late in the day, but we do stick to our interpretation of the statute. And if the court will indulge me, and I know it's a dense statute, if the court will indulge me, I'd like to try to walk through the statute. So the statute sets up a couple of different tracks, right? So if you start out reading 722.23, 1A. So following the arraignment of a defendant charged with a crime committed when he or she was 16 or commencing October 1st, 2019, 17, other than a Class A felony, except for those defined in Article 220 of the Penal Law, which are drug crimes, right? Or a violent felony defined in Section 7002 of the Penal Law, which includes the assault and gang assault and manslaughter charges here, right? Or a felony listed in paragraph 1 or 2 of subdivision 42 of Section 1.20 of this chapter, which I believe refers to some homicide offenses, but don't quote me on that offhand, okay? Or an offense set forth in the Vehicle and Traffic Law. The court shall order the removal of the action to family court in accordance with the applicable provisions of Article 725 of this title. So unless you have, so for our purposes here, unless you have a violent felony or a homicide, the case, there's a presumption that the case is removed to family court unless within 30 days of arraignment, the district attorney makes a motion to prevent removal of the action pursuant to this subdivision. Now, that's talking about the extraordinary circumstances motion that Justice Acosta mentioned. Now, extraordinary circumstances is not the first cut motion for a violent felony. So this is all talking about when you have a nonviolent felony charge. If you have a nonviolent felony charge, the district attorney's only recourse is to appeal to the judge on extraordinary circumstances ground. That's the second part of what happened here. In a violent felony case, that doesn't happen unless the first part of the proceeding terminates in the defendant's favor. So if you skip down to subdivision 2A, it says, upon the arraignment of a defendant charged with the crime, and again, talk about the age of the defendant, other than those defined in, on the Class A felony, other than those defined in Article 220 of the Penal Law, which is the felony murder charge here, right? Or a violent felony defined in Section 7002 of the Penal Law, which is the assault, gang assault, manslaughter charges, etc. The court shall schedule an appearance no later than 6 calendar days from such arraignment for the purpose of reviewing the accusatory instrument, so that includes the indictment, right, pursuant to this subdivision. The court shall notify the district attorney and defendant regarding the purpose of such appearance. So upon such appearance, the court shall review the accusatory instrument and any other relevant facts for the purpose of making a termination pursuant to pursuant to paragraph C of this subdivision. Both parties may be heard and submit information relevant to the determination. The court shall order the action to proceed in accordance with subdivision 1, and that means removal to family court absent exceptional circumstances, okay? Unless, after reviewing the papers and hearing from the parties, the court determines in writing that the district attorney proved by a preponderance of the evidence one or more of the following as set forth in the accusatory instrument. And one is the one relevant here. The defendant caused significant physical injury to a person other than the participant in the charged crime. Two is the display of the...
And what happens if the court makes an error, a legal error, in finding that the defendant did not cause significant physical injury? Let's assume we disagree with the trial court with respect to the nature of the injury. We find that they were significant.
Right.
In this case.
So then what happened?
Then?
So what happened here, Your Honor, is that now if the judge makes that finding, there's no removal because the action, you don't go back and have the action proceed under subdivision 1. Subdivision 1 is about removal. If the action doesn't proceed under subdivision 1, it stays in the youth participant.
But how do we get to review the validity or the correctness of the legal error made by the trial court? Do we do that by a writ of let me put it differently. Where in the statute do you have a right to appeal that determination?
Right. Okay, so Your Honor, I think this case is a case in point, and if I may, I'll explain what happened here.
Okay.
So after the judge denied the people's motion on the retention hearing by saying that the defendant didn't cause significant physical injury to a victim.
Right.
After the judge made that ruling, that kicks the case back up to subdivision 1. All right, so what does subdivision 1 say? Subdivision 1 says that you remove the case to family court unless there's a showing of exceptional circumstances. So that gives the people a second bite at the apple in a sense to go to the judge and say, all right, I know you found that the defendant didn't cause significant physical injury, but you can submit to the court that these are exceptional circumstances, and that's what we did in this case. Justice Samaj...
And the court disagreed.
Disagreed, denied, and we have arguments in our papers about that, which I will not repeat today unless the court wants me to.
Thank you.
But that's the second bite of the apple. After that exceptional circumstances motion is denied, then the action has to proceed under subdivision 1 of 722.23, which means you remove it to family court. Now, once it's removed to family court, the criminal action is terminated. And at that point, that is where the people have the right, as we argue, to seek a writ of prohibition, as was done in Clark.
An extraordinary remedy. But
yes.
So there's nothing in the statute that gives you that appeal right, that determination.
No, there is no appeal right in
this. The proceeding is terminated. According to this statute, to the Raise the Age statute, you're done.
Your Honor,
You found a very clever way of saying, well, we have a writ of prohibition. Why can we move, assuming that we meet the elements under a writ, which is a really extraordinary thing.
It is, Your Honor, and the reason we brought the writ in this case is because this is an extraordinary case. It's not only extraordinary on its facts, but it's extraordinary in the sense that the judge actually added words to the statute that did not exist, and by doing so thwarted the will of the legislature to keep substantial cases like manslaughter, gang assault, and murder cases in Supreme Court rather than family court.
Okay, thank you.
Thank you
both. This was great.
Thank you so much. Thank you.